A critically important part of any lawsuit is the concept of jurisdiction. There are two types of jurisdiction, both of which have to be present in order for a court to have the power to hear a case. The first is personal jurisdiction, that is the power of the court over the individual, including the power to issue a judgment against that person. The second is subject matter jurisdiction, which refers to the power of the court to hear a given type of case. So I'd like to go through each and explain a bit more. So personal jurisdiction, the general rule is what we call minimum contacts with the forum. So the idea here is one of fairness and due process. In order to be subject to a lawsuit in the state of Georgia, a defendant has to have done something to justify bringing them to court here. It could be causing a car accident in the Georgia highway system. It could be doing business in the state or owning property in the state. Note that the basis for personal jurisdiction has to have a connection with the cause of action. So there's a nexus requirement, as the law calls it, as well. But the important thing to remember about personal jurisdiction is that it can be waived. So the rule is that if a defendant does not assert the defense of lack of personal jurisdiction in the defendant's first defensive pleading, then the defense is waived. So a party can consent to hearing a case in a forum other than where they reside, or they could just inadvertently waive the defense. And that's why it's so important for defendants to, if they're going to include that defense, they have to preserve it by raising it in their first defensive pleading, typically their answer. As to subject matter jurisdiction, again, this refers to the ability of the court to hear a type of case, but unlike personal jurisdiction, it can never be waived. So if a court has the power to hear a case, it has the power to hear the case. If it doesn't, it never can be waived. You can't change that. You can't consent and say, oh, I'm okay with having my bankruptcy case heard in a non-bankruptcy court. No, not going to fly. There are clear examples of this, and there are less clear examples. I'll give a couple broadly. One is in state court, and the other is going to be in federal court. So in state courts, in Georgia, every county's got a superior court. Most larger counties also have a state court. There are certain types of cases, though, that can only be brought in superior court. If I have a personal injury case, I can bring it in either state or superior court in Georgia. But if it's a divorce case, child custody case, or a felony criminal case, the case can only be heard in superior court. The state courts have limited jurisdiction to hear certain types of cases. Now I'll talk about federal courts. Federal courts, generally there's two requirements, or not two requirements, but two options for jurisdiction. There's more than two, but the two are the most common are federal question jurisdiction and diversity of citizenship. So I'll take those in reverse order. Diversity jurisdiction has two components. First is the amount in controversy has to exceed $75,000. And second, the parties to the case have to be citizens of different states. So if the plaintiff is suing, say a Georgia resident is suing a Florida resident for some amount of money that exceeds $75,000, then there is the Georgia resident has the option to bring the case in federal court. I won't get into too much in the weeds on this, but that Georgia resident, depending on the type of case, let's say it's a car accident and it happened in Georgia, they could also sue in state court in Georgia, but the defendant could remove to federal court and choose to have the case heard in federal court. The underlying concept there is one of fairness. Again, it's generally perhaps the Georgia resident is a huge dog fan and the Florida resident is a huge Gator fan, and they feel like the judge is a dog fan in the Georgia state court, and they'd rather be with the Gator fan judge in federal court. I kid. Nothing against our Gator brethren. But in terms of another example for federal question jurisdiction, there are certain types of cases that are very clear cut, like a case that arises under federal civil rights statute or employment discrimination cases or labor law cases, copyright violations. But there are some cases that are a little less clear cut. Those are ones that arise under state law but have a federal ingredient, as the courts call it. So an example here would be a contract dispute over who owns a copyright or who has royalty, who deserves royalties. There may be a copyright ingredient to the case, but if the case is purely a matter of contract law, then a state court can hear that case, even if they have to interpret or apply the Copyright Act. But if the case arises under the Copyright Act, in other words, the case is brought for violation of copyright law, then it's going to be a federal case. There are other examples, but I'm going to leave it at that. If you made it this far, thank you so much for watching. Hopefully this has been informative.